Welcome to today's deep dive, where we'll be exploring this legal maneuver in California lawsuits that can really flip the script.
Yeah, it's pretty amazing how these cross complaints can switch a defendant from just, playing defense to actually going on the offense.
For this deep dive, we're using a legal practice guide on California civil procedure. It might sound a bit dry, but things get really interesting.
Definitely. Imagine being sued, and instead of just trying to, get out of it, you use that lawsuit to bring your own claim against the person suing you.
Okay, so let's break this down. What is a cross complaint exactly?
It's basically a mini lawsuit within a lawsuit. It's a way for someone who's being sued to file their own separate claim against the person suing them, or even bring in a whole other person who wasn't originally part of the lawsuit.
So it's more than just saying, hey, I didn't do it.
Oh, yeah. It's about trying to get your own relief back. Let's say someone sues you for causing a car accident. Well, you could file a cross complaint saying that a third party, someone who wasn't even mentioned in the original lawsuit, was actually the one who caused the accident.
So it goes way beyond just defending yourself.
Yeah, you're actually seeking damages from that third party.
Wow, that's a whole new angle. So, can you always just file a cross complaint against whoever's suing you, no matter what the claim is about?
When it comes to cross complaints against the plaintiff, the person who's suing you, California law is pretty open. You can pretty much always file one, even if it's not related to what they're suing you for.
Wait, really? So I could get sued for, say, breach of contract, and I could just turn around and sue that same person for something completely random?
In theory, yes, although the judge might think that's a bit odd.
I bet.
But the idea is that you can bring up all your grievances with the person who's suing you at once. It's all about efficiency, trying to resolve all the disputes in one single lawsuit.
That sounds efficient, but I can also see how it could get really complicated. But I'm guessing there are situations where filing a cross complaint isn't just a choice, but it's something you absolutely have to do.
That's right. There are these things called compulsory cross complaints. It means if you have these types of claims, you absolutely have to bring them up in the existing lawsuit, or you lose your chance to ever sue over them.
That sounds serious. What makes a cross complaint compulsory?
It all comes down to whether your claim is related to the original lawsuit or not. California courts use this thing called the same transaction rule. Basically, if your claim arises from the same set of events that led to their lawsuit against you, it's compulsory. You have to bring it up now.
So it's like saying you can't chop off a branch of a tree and pretend it has nothing to do with the trunk.
Exactly. It's all connected. There was this case, Align Technology, that really illustrates this. It was about this employee who got sued by their employer for breach of contract, and the employee wanted to countersue for wrongful termination. The court said, nope, those are all part of the same employment relationship. You got to deal with them together.
So basically, you can't separate things that are fundamentally linked.
Right. And courts can be pretty broad in how they define related. Even if your claim is based on a different legal theory, it can still be considered part of the same transaction if it shares a factual origin.
So the stakes are pretty high if you miss that compulsory deadline. What happens if you realize too late that you should have filed a cross complaint? Are you just out of luck?
Not necessarily. California courts do have a little wiggle room. Sometimes, even if you initially missed filing a compulsory cross complaint, they might let you file it later as long as you weren't trying to be sneaky or anything.
Okay, that's good to know. So we've been talking about this same transaction rule, but what about cross complaints against other people, like those co-defendants or new parties you mentioned earlier? Do those same rules apply?
Actually, that's where things change a bit. You see, for claims against the plaintiff, they can be totally unrelated, but claims against anyone else have to be related to the subject matter of the original lawsuit.
So you're saying it's not enough that they're somehow connected to the plaintiff. It has to be tied to the case itself.
Precisely. Think of a construction defect case. Let's say a homeowner sues a contractor for shoddy work. The contractor might then file a cross complaint against the subcontractors, claiming that they were the ones who messed up. Since everything revolves around that same construction project, it's all connected. But they couldn't just randomly throw in an unrelated claim, like a personal debt owed by one of the subcontractors, for example.
So the connection has to be clear. Are there ever situations where cross complaints against these other parties are limited or even off limits?
Absolutely. There are these public policy exceptions that are meant to protect specific relationships or prevent the system from being abused.
What kind of exceptions?
For example, in legal malpractice cases. If a lawyer gets sued for messing up a case, they can't just turn around and file a cross complaint against another lawyer who is hired to try to fix things.
I see. But why not? Wouldn't they have a valid claim if the second lawyer made things worse?
The thinking is that allowing that could create a conflict of interest and discourage lawyers from taking on those kinds of cases to help clients who've been harmed by bad legal work.
Hmm.
The priority is on protecting the client, not letting lawyers battle it out.
So the focus is on what's best for the client.
Right. And there are other examples, too, like
Yeah.
cases involving condo homeowners associations, where the law specifically limits certain types of cross-complaints to protect the association and its members.
So this is all about keeping things fair and manageable.
Exactly. Now, I know we've covered a lot about the basics, but I'm really curious about how the statute of limitations plays into all this. You mentioned it earlier, and it seems like a crucial piece of the puzzle. You're right. The statute of limitations sets these deadlines for when you can file a lawsuit, and cross-complaints are no exception.
Mm.
But here's where things get really interesting.
Oh, all ears.
Okay, imagine this. But the time limit to file a particular claim has already passed before the initial lawsuit was even filed. Normally, you'd be out of luck, right?
Yeah, that's how statutes of limitations work. You snooze, you lose, or however that saying goes.
But when it comes to cross-complaints against the plaintiff, there's this incredible twist. Even if your claim would normally be barred by the statute of limitations, you can still bring it up in a cross-complaint.
Hold on, what? How is that even possible?
It's all thanks to this thing called the relation back doctrine. It basically treats your cross-complaint like it was filed on the same date as the original lawsuit against you. So if the plaintiff's lawsuit was filed on time, your cross-complaint can kind of piggyback on that and avoid the statute of limitations.
So it's like I get a free pass on the deadline just because I was sued first.
Precisely. It's like a bonus for being the defendant. You can really turn the tables in a case.
I bet. So does this relation back thing apply to any cross-complaint against the plaintiff or only to those compulsory ones we were talking about before?
That's a great question. And to be honest, the law isn't 100% clear on that. Some courts have said that relation back only applies to compulsory cross-complaints, the ones that are directly related to the original lawsuit.
Okay, that kind of makes sense.
Yeah, the idea is that the plaintiff, by filing their lawsuit, is essentially opening the door for those related issues to be addressed. But other courts have taken a broader view, arguing that any cross-claim against the plaintiff should benefit from this relation back rule, whether it's related or not.
So there's still some debate about how far this relation back thing can go.
That's right. But overall, I think this deep dive has been super helpful in getting a handle on these cross complaints and how they can add a whole new level of strategy to a lawsuit.
I agree. It's been incredibly insightful learning about what a cross complaint is, the different types, and the strategic thinking that goes into using them. But before we wrap up this part, I think we should take a closer look at those public policy exceptions we talked about. They seem like a really important piece of the puzzle.
Yeah, those exceptions are fascinating. They show how the legal system tries to balance everyone's rights and prevent things from getting out of control.
I'm looking forward to diving deeper into those. Welcome back to our deep dive into cross complaints in California. Now, before the break, we were talking about how that relation back doctrine can give defendants a real advantage when it comes to the statute of limitations.
Definitely, it's a powerful tool that can basically bring back a claim that would have been dead in the water.
Huh.
But it also raises some interesting questions about fairness, and if someone's just being strategic.
Yeah, for sure. It seems like there's a lot for lawyers to think about when they're deciding whether or not to file one of these. It's not a simple decision.
No, not at all. It's a strategic move. You really have to think about what you could gain, but also the risks involved.
So what are some of the pros and cons? What are those lawyers weighing when they make this decision?
Well, one of the biggest advantages is just pure efficiency. Instead of having a bunch of separate lawsuits going on in different courts, you can combine everything into one single case.
Right. That makes sense. Keeping everything streamlined.
Exactly.
Yeah.
And when you bring all the claims together, sometimes it actually creates a better environment for reaching a settlement. Everyone's at the table, they see the whole picture, and it can lead to a more complete resolution.
So it's like ripping off the bandage all at once instead of slowly peeling it off bit by bit.
I like that analogy. But there are some downsides, too. Sometimes a cross-complaint can actually backfire, especially if it makes the whole lawsuit a lot more complicated.
Yeah.
Like, imagine a simple case with a straightforward complaint, and then, bam, you hit them with a cross-complaint that brings in a bunch of new people and new issues.
Right. It could really overwhelm the jury.
Exactly. It could drag out the trial and end up hurting your client in the end.
So you don't want to overcomplicate things.
Right. And sometimes, filing a totally separate lawsuit might be the better strategy, especially if you think your client's claim might get overshadowed or mixed up with the original lawsuit. This way you can control how their case is presented, make it stand on its own.
So there's no magic formula. It all depends on the specifics of the case.
Exactly. It's about figuring out the best path for your client. So thinking about all these strategies, let's talk about actually writing one of these cross complaints. What are the key things you need? Is it pretty similar to a regular complaint?
Good question.
Structurally, yeah, it's very similar. You still need all the basic stuff, like, identifying all the parties involved, laying out the facts of your client's claim, and what you're asking for. But there's some specific rules you have to follow.
Okay, like what?
For example, in California, you have to file it as a totally separate document. You can't just stick it in with your answer to the original complaint.
It's like it has its own life.
Exactly.
Yeah.
And you can also do this thing where you basically refer back to information that's already been presented in other court documents. So, like, if the original complaint already lays out certain facts that support your cross-complaint, you don't have to write it all out again.
That's good for efficiency.
Right, it keeps things from getting too repetitive. But there are definitely a lot of details to keep track of. And to make things a bit easier, California actually has these standardized forms for certain types of cases, like breach of contract or personal injury.
Fill in the blank legal documents.
Kind of, but with way higher stakes. It can definitely simplify things, especially for more straightforward situations. But you still need to understand the law behind it all and make sure you're using the right form for your case.
So we've got the form. Now, what about deadlines? Are those different for cross complaints?
Yeah, there are some timelines to watch out for. If you're filing a cross-complaint against the plaintiff at the same time as you file your answer, you're good. You don't need any special permission.
That's like an automatic, right?
Exactly. But for cross-complaints against other parties like, co-defendants or new people you're bringing in, you have until the court sets the first trial date. After that, you got to ask a court for permission and might not always say yes.
So you really don't want to wait until the last minute.
Exactly. And once you've filed it, you got to make sure everyone involved gets a copy properly served.
So are the rules for serving someone with a cross complaint the same as with a regular complaint?
It depends. If the person you're serving is already involved in the case, like the plaintiff or a co-defendant, you can usually just mail it to their lawyer.
Makes sense. What about if you're bringing in someone new, someone who wasn't part of the original lawsuit?
But you got to do the whole formal service of process thing, which basically means hand-delivering them a copy of the cross-complaint along with a summons.
So it's a lot more official.
Yeah, you can't just casually slip it to them. It's a crucial step to make sure everyone's in the loop and has a fair chance to respond. And speaking of responding, whoever you serve has to file their response to the cross-complaint within a certain amount of time, usually 30 days.
Otherwise,
Otherwise, the court might just rule against them automatically, so ignoring it is not an option.
definitely not. So what kind of responses can they give? Is it basically the same options they have with a regular complaint?
Yeah, pretty much. They can file an answer, object to it, try to strike parts of it, or use any other legal move to try to challenge it. But California also gives cross-defendants this special tool called a special answer.
Okay, a special answer. What's so special about it?
It's a way for them, especially in those situations where they might be held liable for damages caused by the original defendant, to bring up defenses that the original defendant didn't use.
So it's kind of like a backup, making sure all the bases are covered.
Exactly.
Yeah.
Like, let's say the original complaint should have been thrown out because of the statute of limitations, but the defendant didn't bring that up. The cross-defendant can use a special answer to point that out to the court and maybe get the whole case dismissed.
Wow, that's powerful. It seems like these cross complaints add a whole new layer of complexity to this legal game.
They do.
Yeah.
You really have to understand the rules and procedures and how to use them strategically. It's essential for anyone who's involved in a lawsuit in California where these cross-complaints are at play.
It's been really insightful learning about all this, from what a cross complaint is to the strategies involved in drafting and filing them. But before we finish up this part, I want to go back to those public policy exceptions we mentioned before.
Oh, yeah. Those are really interesting. They really show how the legal system tries to find that balance between letting people make their claims and protecting certain relationships or preventing abuse.
Exactly. It's not just about blindly following the rules. It's about making sure things are fair and the system isn't being used to hurt people.
Right. And I think that talking about those exceptions will really help our listeners understand the ethics involved in all this.
I agree. So let's jump into those public policy limitations and see what we find. Stay tuned because we're going even deeper into the world of cross complaints. Welcome back to the deep dive. We've been digging into these cross complaints and California lawsuits, and now it's time to finally tackle those public policy exceptions.
Yeah, these exceptions are like built-in safety measures. They make sure people aren't using cross complaints to, you know, mess up certain relationships or give themselves an unfair advantage.
It's interesting how the law tries to balance things out, letting people make their claims, but also protecting those who are vulnerable.
Exactly. Yeah. It's not always a simple answer. And those public policy exceptions really highlight that.
So let's go back to some of those examples we talked about before. Remember how you said a lawyer who gets sued for malpractice can't just turn around and file a cross complaint against another lawyer who is brought in to fix the problem? Why is that?
Well, the courts realized that allowing those kinds of cross complaints could really damage the relationship between a lawyer and their client.
Yeah.
And imagine you're a client and, your lawyer could potentially sue your previous lawyer. It might make you hesitant to be completely honest with them.
Yeah, you'd always be second guessing yourself.
Exactly.
Yeah.
And it could also discourage lawyers from taking on cases where they need to help clients who've been hurt by bad legal work. I mean, who wants to step into a situation where they might immediately get hit with a lawsuit from the client's old lawyer?
Right. It seems like it would put the lawyer's interests ahead of the client's.
That's the worry. And that's why courts have stepped in and said, nope, we need to put the client first and protect that attorney-client relationship.
Makes sense. So it's not just about playing the legal game. It's about making sure the legal profession maintains its integrity.
Absolutely. The law is about more than just winning. It's about doing what's right.
Now, you also mentioned some limitations on cross complaints against condo homeowners associations. Could you break down the logic behind those?
Sure. So California law allows these homeowners associations to sue on behalf of all their members for certain types of damages. Like, let's say there's a construction defect that impacts a bunch of units in a condo complex. The association can file a single lawsuit against the developer or the contractor instead of each individual homeowner having to sue separately.
That's way more efficient.
Definitely. But to prevent those defendants from then turning around and suing all those individual homeowners through cross complaints, the law specifically prohibits that in these cases.
So it's like a shield to protect homeowners from getting dragged into these legal battles and racking up huge legal bills.
Exactly. And you have to remember, these homeowners associations often have limited funds. So allowing these cross complaints could really put a strain on them and discourage them from filing legitimate claims in the first place.
It's about leveling the playing field, right? Making sure those with more money and power can't just bully everyone else.
That's a big part of it. And it also helps to keep the peace within these associations. By preventing cross complaints against individual homeowners, it avoids turning neighbors against each other.
So it goes beyond just the legal stuff. It's about keeping the community together.
You got it.
Wow.
The law has to consider the bigger picture, the impact its rules have on society, and these public policy exceptions really show that.
All these examples really show how these cross complaints can be really powerful, but also how the law needs to set boundaries to prevent them from being misused.
Yeah, it's all about finding that balance between letting people pursue their claims and making sure the outcome is fair.
This has been such an informative deep dive. We started with the basics of what a cross complaint is, then got into the strategic thinking behind using them, and now we've explored all these fascinating public policy exceptions.
It's been quite a journey, uncovering all the intricacies of California's civil procedure, and I really hope our listeners now have a better grasp of the nuances of this area of law.
I'm sure they do. But before we sign off, I want to leave everyone with something to think about, a question to ponder as they navigate the legal world.
Okay, I'm curious. What question do you have for our deep divers?
Remember that relation-backed doctrine we talked about? The one that lets a defendant's cross-complaint against the plaintiff get around the statute of limitations?
How could I forget? It's such a game changer.
Here's the question. Why does that rule only apply when it's against the plaintiff? Why not let relation back work for cross-complaints against other defendants or new people brought into the case?
That's a really good question.
Yeah.
It makes you think about why that limitation even exists. Is it about being fair? Is it about efficiency? Or is it just some random leftover from how the legal system evolved?
It's definitely something to think about. What are your thoughts, listeners? We'd love to hear your take on this. Head over to our social media pages and let us know what you think.
And while you're there, let us know what other legal mysteries you'd like us to unravel on future episodes of The Deep Dive.
Until then, happy diving.